arrange it, introduce it into the tape? Or no?
Your Honor, today we have a hearing in the matter of CFI 014/2016. First claimant, Mr. Rafed Khorafi. Second claimant, Mrs. Amra Ali Abdul Latif Al Hamad. Third claimant, Mrs. Ali Muhammad Sulaiman Al Rafai. Versus first defendant, Bank Sarasin Alpin, open parentheses, Middle East, close parentheses, Limited. Second defendant, Bank J. Safra Sarasin, open parentheses, formerly Bank Sarasin and Co., close parentheses. The claimant is represented by Orlando Frazier QC, assisted by Alastair Thompson, Roger Baldin, Basma Al-Hawari, Hamdan Al-Shamsi from Al-Shamsi Law Firm. The second defendant is represented by Ewan McQuater, QC, Camilla Bingham, QC, assisted by James Abbott, Ritwik Gosh of Clifford and Champs.
Thank you. Yes, Mr. Davis.
No, good afternoon. Your Lordship, as I anticipate, delighted to see Al Khorafi against Bank Sarasin back again in this court. Your Lordship may recall that in introducing the Court of Appeals judgment on the quantum appeal back in January of last year, Justice Sir Richard Field said that the appeal, in paragraph 1, that the appeal against quantum constituted the final chapter, he said, in proceedings that gone as long ago as 2009. Now, apparently not, it would seem. The 2009 proceedings, my Lord, as your Lordship well knows, took some 8 years. In fact, they're still continuing. There's cost assessments ongoing, and I think there's still a ruling to be had on outstanding interest from Deputy Chief Justice Chadwick, which has been outstanding for a while and is still due. So the proceedings are still continuing. The reading list included the agreed chronology, my Lord, which, I won't go there for the moment, but it's in Bundle 1, Tab 3. If your Lordship wishes to remind himself of relevant events as necessary, that's where it is. The 2009 proceedings, my Lord, were hard fought on both sides. There were substantial legal teams on both sides, including Silks, multiple juniors to solicitor teams. They reached trial, as your Lordship will remember, in May of 2013, 19th of May to the 28th of May 2013. Closing submissions were later. There were some 51 odd trial bundles, hundreds of pages of expert reports, banking, Swiss law, Kuwaiti law, cross-examination of witnesses and facts took 7 days odd. And as someone coming into the case, as I am, my Lord, one can get a feel for how heavy duty the litigation was from the liability judgment of Deputy Chief Justice Chadwick after trial, which, for your Lordship's note, is that in Bundle 8 at 75, that runs to 170 odd pages. He delivered a further judgment on quantum issues in October 2015, which runs to another 91 pages. That's Bundle 10, Tab 100. And on the appeals, as your Lordship knows, having been involved, on liability and quantum, the oral argument in the Court of Appeal cumulatively lasted 7 days with two substantial judgments on liability and quantum. They're at Bundle 10, Tab 101, and Bundle 11, 105, respectively, and those run to over 150 pages. Now, this was, by any measure, full-on commercial litigation, and as well as the very substantial time which the parties devoted to it and the expense, it took a very substantial amount of judicial time and resources. Now, Bank Sarasin, my clients, the second defendant, the Swiss entity, spent 8+ years defending it, and that time is continuing. And the claimants are claiming 6.8 million in costs which gives you another idea of the scale of the litigation. And your Lordship, in his judgment, when I referred to Bundle 10-101, described this as litigation on a grand and costly scale. Now, the claimants, I think to justify their currently abusive conduct, say, amongst other things, well, that's the defendant's fault. They took every point. Now, your Lordship will recall that both sides filed very long submissions, which your Lordship criticised. By their nature, of course, the issues were complex. And frankly, if the proceedings were hard fought, that is all the more reason why the claimants should have brought forward their whole case as they were supposed to, and as the Vice-Chancellor Wigram said parties should do as long ago as Henderson in 1843. All the more reason to bring forward their whole case instead of holding back this billion-dollar claim for later. There's an odd suggestion in the claimant's skeleton that the defendants should have rolled over and just paid the claim and avoided the proceedings entirely. Now, my Lord, if the defendants, and if my clients, the second defendant's defence, had been so weak, of course the claimant should have applied to strike it out and have summary judgment, and they did not do so. It's also, of course, emerged since, and emerged from litigation which the first claimant had with his litigation from Ms. Vannon, from a judgment of Justice Sir Richard Field. It's in the bundles at on 10, tab 102. It's emerged that the claimants concluded a revised funding agreement in April of 2013 following Vannon's receipt of legal advice from Jeremy Cousins QC, saying that the claimant's misrepresentation case had no more than a 35% chance of success, and the balance, and on the balance of liability issues, no more than a 40% chance of success. Now, not surprising, the litigation was contested. Now, my client, as far as my client, the Swiss entity, is concerned, there was never any award of costs on an indemnity basis against it. Your Lordship may recall Deputy Chief Justice Chadwick's judgment on costs of trial is in the bundles at 9 tab 78, and he expressly distinguished the position of the first and second defendants in this, making findings inter alia that the second defendant did not know about what he found to be falsification of application forms, etc., no KYC forms, etc. And when it came to the quantum costs in his judgment in the bundles at 10 at 104, the Deputy Chief Justice, dealing with costs of the quantum issues, indemnity costs were sought against my client and were refused. And your Lordship may also recall that it was in fact the first defendant which made the running on many of the appeal points on fact. And of course, on the court's substantive rulings in the case, my client, obviously, the second defendant, did not attract the same degree of culpability. Your Lordship will recall from Deputy Chief Justice Chadwick's liability judgment that the sole basis for my client's liability was breach of the financial services prohibition under the Article 41 of the regulatory law, under which they were liable to pay compensation under Article 65. The claimants cheaply assert in their skeleton that Deputy Chief Justice Chadwick found us liable for breach of contract. That's not the case. In paragraph 413 of his judgment, he held there was a contract if there was a breach as to which he didn't make a finding. He said there would have been no damages for which he couldn't compensate under Article 65, so he didn't make a finding of breach. No, so that was the sole basis of liability against my clients, and on that basis they were found liable to pay some $25 million out. Some 10.5 million losses in the value of the notes, and $24.5 million in respect of interest and bank charges incurred in relation to the claimant's borrowings to purchase the notes. Now, those sums were paid, as the claimants accept. And so the bank, the second defendant, has met its obligations in full under the court's judgments. The claimant's skeletons refer to the outstanding claim for interest, which is before the court and to be resolved. Now, by contrast, well, of course, the first defendant, Sarasin Alpin, was also found liable to pay multiple damages under Article 40, Sub 2 of the Law of Remedies and Damages. That was only sought and only awarded against that Sarasin Alpin, the first defendant. There's never at any stage been a finding that the second defendant was privy to wrongdoing by first defendant employees. Your Lordship found in the Court of Appeal, of course, that for the purposes of the regulatory law, there was to be attribution of acts of the first defendant's personnel to the Swiss entity. But there was no finding that they actually were at any stage aware that the first defendant's employees were engaged in any wrongdoing. Now, so it is, in my submission, entirely unmeritorious for the claimants to submit, as they do in their skeleton, paragraphs 96 to 99, that the second defendant behaved so badly first time around that the court shouldn't mind if it is harassed or oppressed this time around. That's an unmeritorious submission, my Lord, and it is, in my submission, entirely appropriate that the second defendant should complain about being harassed in this $1 billion claim. Now, my Lord, I will develop these points, but by way of short summary as to why the claim is abusive in the 2016 proceedings. The real estate losses and the deceit claim could and clearly should have been brought in the 2009 proceedings, which were heavyweight proceedings, multi-million-dollar proceedings, and very costly. The first claimant knew about the real estate losses, now said to be a huge figure, long before trial, and it's his case that they were caused by investment in the notes. And the claimants in the 2009 proceedings were always claiming on a no transaction basis for all losses incurred from having bought the notes. And by 2012, most of the losses had even been quantified. As to the deceit claim, the statement in August 2009 on which that claim is based was already part of the 2009 action. There is a pleading of dishonesty now made on the basis of information that the claimants had years ago and had well before the 2009 trial. There has been a wholesale and inexcusable breach of the mandatory Aldi guidelines under which the claimants should have raised these matters with the court and with the defendants at an early stage. That breach has resulted in very significant prejudice to the second defendant. Prejudice in terms of the potentially years of further litigation it now faces, with all the time, costs, inconvenience, risk, lack of finality which that entails, including duplication of costs from the first proceedings. Prejudice because it's contrary to all the policy considerations which are behind the Henderson abuse jurisdiction. That is to say, lack of finality litigation, ensuring a defendant is not vexed twice in the same matter, and abuse of court resources, which is, importantly, is happening here. Moreover, the breach of the Aldi guidelines has potentially given the first claimant a strong litigation advantage in the second proceedings. Whether holding the claims back was deliberate or not, it has in fact potentially given them a strong litigation advantage, which is completely unfair. And the second defendant, on this application, we say they are being unfairly harassed and oppressed. And to cap it all, if that were not enough, there was a collateral attack on the loss rulings in the 2009 action, and we're being sued for a second time in breach of the exclusive jurisdiction clause, in which the first claimant promised to sue us in Switzerland. Now, my Lord, just to develop a few of these points, if I may, it was a feature of the 2009 proceedings, my Lord, as your Lordship will recall, that multi-million-dollar litigation, that it had, because this is covered in your Lordship's judgments too, it had as part of the acts in issue the very statement in August 2007, which in the new proceedings is used as the basis for all the new causes of action in deceit, negligence and breach of duty. So it's used as the basis for this eye-catching $1 billion claim for damages, which, as your Lordship will note, is some 30 times the damages awarded against my clients first time around, and it's some 13 times the size of the claim made in the particulars of claim the first time around. And it's obviously a pretty extraordinary sum compared to the losses sustained on the notes themselves, which were of the orders that I've just told you, Lordship. The role of the statement, the August 07 statement in the first proceedings, has a twofold significance in my submission. It shows, first of all, that the claims in deceit and indeed the related claims in negligence could have been made in the 2009 action. And secondly, given that the statement so clearly was in fact part of the subject matter of that action, that's the strongest possible indication that the claims should have been made in the 2009 proceedings. Now, my Lord, before I turn to the role of the statement in the first action and whether the deceit claim properly belonged there, I want to make this point that in one sense the deceit claim is something of a distraction. Now I say that for this reason, because if you look at what the first claimant is trying to do in the 2016 proceedings, he is trying to claim for real estate losses of some $1 billion. My Lord, it has never been necessary, in order for the first claimant to claim those losses, to bring a claim in deceit on the basis of the August 07 statement, or even a claim based on that statement at all. One of the clearest indications of that, which I will come to, are the fact that the first claimant tried too late to claim some of those losses in the first action, and the fact that in the new proceedings the claimant is claiming the same loss on the basis of both deceit and negligence and breach of duty. Now, the real estate losses on the claimant's own case were caused by the mis-selling of the investment in the notes. That was the very thing, my Lord, that they were complaining about in the first proceedings. And I just need to show you, Lordship, the first claimant's own evidence about that, which is in Bundle 9, that's tab 84, and page 4271. This evidence, my Lord,
Sorry, just repeat the reference.
it's Bundle 9, tab 84.
Okay.
It starts at page 4271, and this is a witness statement of the first claimant in November 2014. So this is when the claimant, in a very late stage, sought to claim some of the Al Khorafi tower losses in the 2009 proceedings. At that point, said to be a relatively modest $35 million. And Mr. Al Khorafi deals with the tower losses in this statement from paragraph 11 onwards. He addresses those losses, and then he says at page 4274, paragraph 19, if I had not been missold investments by the defendants, I would not have experienced the cash flow difficulties which I did between 2009 and 2014. In those circumstances, I would not have had any difficulties in making regular loan repayments on behalf of Rafed. Now, that's his property development company, the failure of which is the subject of his current loss claim. Rafed would have retained the land to see the tower being completed on it. That would have been a profitable development, and the monies raised would have been sufficient to repay the Rafed loan and all the interest paid by me on the Rafed loan. In addition, there would have been a profit element to the land would not have been auctioned at undervalue. We get the same story at that same stage at tab 82 of the same bundle, where Mr. Al-Shamsi's evidence is to similar effect. And he addresses the matter on, this is in a witness statement made on behalf of the claimants. He addresses the matter at page 4244, paragraph 12. Again, he's addressing the tower, the Al-Khorafi tower losses. Losses relating to Mr. Al-Khorafi's property development in Kuwait. Refer to Mr. Khorafi's witness statement, which explains the losses sustained by him as a result of the sale of an undervalued real estate owned by his company. The losses sustained total 35 million. They are as follows. And if I could perhaps just invite your Lordship to read a little A and a little B which follow.
Yeah.
So they are saying the tower real estate losses were caused by the matters that we're complaining about in the 2009 action, the mis-selling of the notes. And it's also put in terms, if your Lordship can put 9 away from that, if your Lordship will take that bundle 10 for just one reference. At tab 95. One sees a skeleton argument. This is page starts at 4752. This is, just to explain, the claimant's skeleton argument for their appeal, complaining that the tower losses had been excluded from the 2009 proceedings. And paragraph 29, we can direct your Lordship's attention to on page 4760, where in the second half of the paragraph, the skeleton says this, as explained in paragraph 19 of RAK 4, had it not been for the Sarasin investments, the first claimant would have been able to service the Rafed loan repayments, the tower would have been completed, the property would not have had to be auctioned off at another value, and its personal guarantee would not have been called on. So
I'm not quite sure I understand. This is the skeleton in support of what appeal?
What happened below, my Lord, was that over a year after trial, the claimants sought and after Deputy Chief Justice Chadwick gave a judgment. He gave judgment about August 2014.
Yeah.
And then in November 2014, they made an attempt to claim some of the real estate losses in the first action.
Understood.
So and those were the Al-Khorafi tower losses. Now, what happened then was that Deputy Chief Justice Chadwick, and I'll come to it because this goes to the collateral attack point, rejected that attempt, and they tried to appeal that to, and Justice Sir Roger Giles refused that, and they had another go for reconsideration, and Sir Richard Field refused that. and this was sworn, skeleton argument was one of the skeletons they put forward trying to get permission to appeal from Deputy Chief Justice Chandler. So that's the context. Now, so we see it expressly stated there that these real estate losses were caused by the investment in the notes, which was the complaint in the first trial. And we will see, because I'll come to the references when I deal with the real estate losses now, that the first claimant knew about those losses long before the trial of the 2009 proceedings, and inexcusably failed in our submission to amend to bring those losses in good time before trial in the 2009 proceedings. And that was in wholesale breach of the ALDI guidelines, and most of the losses that are now claimed for were not even intimated at that time, and there was a very late attempt to bring in some of the tower losses. Now, I'll come back to those rulings, my lord, but I deal with collateral attack. I'll show you, Roger, what was said in those rulings. But that episode of attempting to get the tower losses too late into the 2009 action also demonstrates that it was not necessary to plead deceit in relation to the statement in order to make those real estate loss claims in the first action. And for the claimants to claim these losses now in the 2016 proceedings against the same defendant on the basis of the same story or the same old charge as Wright and Bennett would have put, if that's the case referred to in paragraph 11 of our skeleton, arising out of the same facts, in our submission is classically abusive. It's really, my lord, what this jurisdiction at its core is about. It's about the defendant being vexed twice in the same matter. And we now have a new 50-page statement of claim, particulars of claim, which we're told by Mr. Al-Shamsi was prepared by a team of barristers over many months. And we're told in Mr. Bowden's evidence that it's projected, according to the claimants, to have a trial of several weeks. Now, claiming those losses in the having previously held them back, is, in our submission, abusive. And if I could, in this regard, just show you, not to conclude.
Sorry, can we finish with that skeleton argument? Because I just going to ask his lordship to read paragraph 53 of it.
Well, the friend will have this opportunity, of course. If your lordship would pick up our authorities at tab 91.
Tab 91.
Sorry, that's a misreference. It's 11. My one looks like a 9. I do beg your pardon. It's 11. My lord.
That's a relief.
Yes.
Thank you. Well, this is property allowance.
No, tab 11. Your lordship should have. I think your lordship may have the wrong bundle of authorities. This is Johnson and Goldwyn.
Sorry, I've opened the wrong volume.
Yes, I think your lordship was in the Friend authorities bundle. And in our authorities bundle, tab 11 should be Johnson and Goldwyn. And the very well-known passage is at bundle page 134, internal page 31. This is the passage of Lord Bingham and the...
Well, you've, somebody has coloured it for me.
Yes, well indeed, my lord.
Thank you.
Useful for me too. And this is where Lord Bingham articulates the abuse principle for the modern era, effectively. And for present purposes, I just want to remind your lordship of what's said at the top of the page, third line in, where it says the underlying public interest is the same, that there should be finality in litigation, and that a party should not be vexed twice in the same matter. this public interest is reinforced by the current emphasis on efficiency and economy in the conduct of litigation in the interests of the parties and the public as a whole. Now, all of those considerations go out of the window if this claim is allowed to proceed, because you have lack of finality, you have a party being vexed very obviously twice in the same matter, and the efficient and economic conduct of litigation goes out of the window as well. And that's something which not just the parties but the public have an interest as well. And of course, there is an egregious misuse of court resources. And in my submission, the deceit claim is really a fig leaf justification for bringing these huge heads of loss now and trying to circumvent the Deputy Chief Justice's decision in the 2009 proceeding saying they couldn't bring them in. It said, oh, we weren't in a position to plead dishonestly. Well, there's nothing in that point, as I will show you, Lordship. But in any event, pleading a claim for the real estate losses was never dependent on pleading fraud or even pleading a case based on the statement. That's implicit on their attempt to bring the Khorafi tower losses into the first action at a late stage. We also see it very clearly from the fact that as I mentioned a moment ago, the various real estate losses in the current action are claimed on the basis of both deceit and negligence and breach of duty. If your Lordship can put the authorities bundle on one side for the moment and take that bundle 1, where you'll find at behind tab 5 the current particulars of the claim. And if your Lordship looks through to paragraph 123, which is on bundle page 49, sorry, it's just page 48. So the heading at the top of page 48 is the deceit claim. And you'll see that at paragraph 123 that it said that but for the deceit, the claimants would have taken the steps in paragraph 143 here. And the same causal mechanism is used for all the claims, because if you look at the breach of duty claim, which is over the first of which is over the page at heading M, breach of advisory duty, it's said in relation to that at the top of page 50. The last sentence, had he been given appropriate advice, he and the other claimants would have taken the steps set out in paragraph 143. And on the negligent misstatement claim, which is heading N at the top of page 51, you'll see the same consequence spelled out in the last sentence of paragraph 136. Had he been given accurate information, he and the other claimants would have taken the steps in paragraph 143. So all roads lead to paragraph 143. And if we look at that paragraph, which is on page 53, we see, this is the same loss and damage case, we see paragraph 143 sets out 10 hurdles for causation of damage in this case that the case went forward, the claimants would have to prove. But effectively, he is saying here, but for this, sorry, let me rephrase that. He's saying here that because of these various wrongs I have pleaded here, including the wrongs in negligence and breach of duty, I have suffered the real estate losses. So the causation and loss claim is the same for negligence and for breach of duty. Now, my friend says in his skeleton, well, the remoteness rules are different for deceit, and that might have been a more favourable route. Well, as a matter of law, there's some truth in that. But obviously, the claimants could have claimed on the basis of negligence or breach of duty in the 2009 proceedings. In fact, they actually tried to do so, but too late, as I mentioned a moment ago. And secondly, my lord, they could actually have claimed on the fraud basis in the 2009 proceedings because they were claiming fraudulent misrepresentation in the 2009 proceedings in relation to the investments. And your lordship gets that if he puts away bundle 1 and takes up bundle 4. At tab 57, you'll see the re-amended particulars of claim in the first act, the 2009 proceedings. And if your lordship on this occasion goes to paragraph 123.
So,
divider 57, my lord. This is the re-amended particular in the first action. And I was going to take your lordship to page 1684, where I hope I will find paragraph 123. Yes, 1684. The heading misrepresentation by Sarasin Dubai. That's the first defendant. And there are various misrepresentations about the investments are alleged, but I want to draw your lordship's attention particularly to sub 4 at the foot of the page, which is the representation about level of risk on the investments. And the last sentence, it says just over the page at 1685, in the premises the capital protection statements were made fraudulently. And in the next subparagraph, which is the capital protection statement, yes, that's on. 4 is on risk, and then at 5, alternatively, in view of these matters, Sarasin Dubai, through the two identified individuals, had no belief in the truth of the capital protection statements or the accompanying representations, or were reckless as to whether or not they were true. The premises of the capital protection statements were made fraudulently. So they were making a case in fraudulent misrepresentation in the first action, and what's more, that's a case against the first defendant. They were also saying we, the second defendant, are liable for that, because if you look, if you turn back 2 pages to 1683, your lordship will see in paragraph 122. The pleading says this: further or alternatively, paragraph 122, in dealing with the claimants, Sarasin Dubai and/or Mr. Wallier and/or Mr. I think we may have to call this gentleman Mr. Blonde because of the previous ruling in this matter, acted as agent for Sarasin Switzerland. Accordingly, pursuant to Article 32 of the Code, their acts and omissions are to be imputed to Sarasin Switzerland, that's the second defendant, which is therefore liable as a matter of Swiss law for the wrong set up below in this re-amended particulars of claim, and in particular the misrepresentation set up below in paragraphs 123 to 127, and the failure to take reasonable care. And that attribution case comes back in this pleading in a number of places. It comes back at paragraph 129, where on page 1691, where they say in the premises, this is misrepresentations by Sarasin Switzerland, that's my part. In the premises of these various paragraphs, Sarasin Dubai and/or Mr. Bayer and/or Mr. Blonde provided services for Sarasin Switzerland, etc., and/or acted as its agent in relation to the transactions complained of with his particulars of claim, and so forth. So now they may have been disappointed they didn't succeed in fraudulent misrepresentation in the first action, my lord, but they were making a deceit claim, and they could have claimed the fraud measure. And if they're going to now say, oh, but we've now got a better deceit claim, that smacks of having had a dry run at the evidence and the cross-examination and testing the evidence and holding back your whole case until after you've got the findings you want. So the deceit claim, my lord, is something of a distraction. It certainly doesn't stand up as a justification for claiming the real estate losses now. And so, my lord, that brings me to the question of the role of the statement in the first action, which is also very relevant to the deceit matter. That requires us, I'm afraid, to look at a couple of references relating to the first action to show the role of the August 2007 statement that is the hinge for the new claim, is that statement that is said to be a deceit in August of 2007. In fact, Your Lordship, actually, you can start with the same documents, Bundle 4, tab 57, which is the particulars of claim in the original case. A case was pleaded about the statement in paragraph 45, which is the top of bundle, page 1658.
So did you say 1658?
Yes, paragraph 45, top of the page.
Yeah, nearly there.
So a case, and this was, I'll be corrected if I'm wrong, this was in the original pleading. We've got the re-amended version here, but this was in the original. It doesn't seem to be one of the amendments. It says on 31 August 2007, Mr. Khorafi transferred 10 million from his own funds to Sarasin, Switzerland, in order to assist with a loan application made in connection with his real estate business. It appears from the portfolio account statement supplied by the claimants on 7 July 2008 that these funds were used to invest in a particular money market, a coal fund. Now, 10 million transferred in August to assist in a loan application, and then invested in that coal deposit. Now, the first defendant's defence to this, which I draw Your Lordship's attention to this, was filed as long ago as the 22nd of December 2010. The first defendant's defence, if Your Lordship puts down bundle 4 for a moment, we will, I'm afraid, need it back. If Your Lordship keeps it somewhere close, we'll need it back. But the first defendant's defence is back in bundle 2 at tab 44. And I'm going to go to page 107, but page 107, where...
Sorry, what page?
1007. It's paragraph 94, my lord.
Thank you.
And foot of page 1007, where paragraph 94, the defence, as paragraph 62 is denied, the portfolio statements were produced and sent by the second defendant. The position on the accounts of the first and second claimants was brought to the attention of Mr. Taha. Just pausing there a moment. Mr. Taha is an accountant who was acting for the first claimant. In a telephone call on the 15th of August 2007 with Mr. Blond, due to the claimant's leveraging strategy as of 15 August 2007, a collateral shortfall existed on the investments. So there was a collateral shortfall on the investments. On volume date 31 August, the sum of 10 million was received on the first claimant's account of the second defendant to resolve the issue of shortfalls on the account. The first and second claimants, as well as Mr. Taha, were aware of the position on the accounts by the monthly portfolio account statements generated by the second defendant and sent to the claimants on a monthly basis. So, and if Your Lordship goes forward to page 1043, you'll see a statement of truth from Mr. Walia, who's the gentleman, first defendant, said to have made the deceitful statement in this case, who signed the statement of truth on the 22nd of December 2010. So you get Mr. Walia signing a statement of truth in December 2010 saying that the money was transferred to resolve a collateral shortfall issue, and indeed that paragraph 94, not only the collateral shortfall existed, but Mr. Taha, the claimant's accountant, was told about it, it was brought to his attention, and the 10 million was resolved it was sent to deal with that. And that's a case that the first defendant was making from that time, end of 2010. And one, which is significant, given, of course, that the claimant must have known what he was told by Mr. Walia in August 2007 about the 10 million. And now he's seen Mr. Walia sign a statement of truth saying what paragraph 94 says. Now, the second defendant, my fact, pleaded a defence later, because there was a jurisdiction dispute, if your lordship remembers, and that later defence essentially made the same case. And the matter proceeded to disclosure, which Mr. Abbott, in his witness statement, tells us was between June and August 2012. And at that time, your lordship can, I think, mercifully put away those bundles. You'll need 4 again later, but you can put away number 2 and 4 we will need again, I'm afraid. But disclosure took place, so latest August 2012, and disclosure was given in relation to the statement, and at bundle 1, tab 29, there are some emails that were disclosed on disclosure. I'm afraid they are in very small typeface in my version. Actually, well, it might be easier if I could read the first paragraph up on the screen. This is from Mr. Blom to someone in Switzerland, the second fellow.
Sorry, we're on 465.
We're on 465.
Yeah.
And the date.
So that's from Mr.
I think you have to call him Mr. Blondon.
Yeah,
some
Mr.
application made about that. So he's Sarasin Alban, the first fellow.
Yes.
And he's sending us to Switzerland
Right.
on the 14th of August.
Okay.
And the first paragraph, he says, I've set up a conference call between the financial advisors and client's son, that's the first claimant, for tomorrow afternoon. We will review the portfolio and the current market conditions and also discuss the margin call. Mrs. Amra continues to be on vacation in southern France. I'd like to request the following, etc. And just the second email in this regard is behind tab 31. So he's treating it as a need for further collateral. And then at tab 31, you get an email from the same gentleman on the 2nd of September 2007, copied to Mr. Walia, subject the first and second claimants. And he's writing to Switzerland, dear Peter, post Rohit, that's Mr. Walia's meeting, Mr. Khorafi in London last week, we have received 10 million into Mr. Khorafi's account as collateral. Now, bearing in mind what Mr. Khorafi knows about what he was told by Mr. Walia, then he then gets on disclosure an email which says they're setting up a call to discuss the margin call, and an email post the meeting in London, saying we've received 10 million from the first claimant as collateral. And we know what the claimant and indeed his office manager, Mr. Noor, always thought about the August 2007 call, because that eventually emerged in their witness statements, which were served closer to trial. They were served in early April 2014. And I can actually, if you're in volume 1, I can see, your lordship can conveniently find what they say, because it's quoted by Mr. Abbott in his witness statement. If your lordship goes to bundle 1, text 17, the second witness statement of Stuart Abbott, James Abbott, he there conveniently cites at paragraphs 36, which is on page 135, what Mr. Noor, the claimant's office manager, says in his witness statement about this statement, first of all, and then he later cites what the first defendant says in paragraph 38. And in paragraph 36, he quotes Mr. Noor, who's saying the following: after the first claimant lost money with the defendants and entered the current dispute, the main real estate projects was planning fell away because of his financial difficulties. Interesting. He obviously knew about the real estate losses already. One of the real estate projects that the first claimant I worked on was Tower City. I understand that the defendants allege that by the end of August 07, the collateral in the account it was in shortfall, and as a result, the first claimant paid a further 10 million to the bank. That's not my recollection of events. I believe the payment of 10 million stems from a call from Mr. Walia to the first claimant sometime in August 07. That call took place while the first claimant and I were in the car in London. I overheard part of the conversation, and the first claimant told me about it afterwards. In essence, Mr. Walia asked me whether the first claimant had used all of the 35 million the bank had advanced to him the previous month. He asked whether he was willing to invest a further 10 million with the bank, Sarasin. Mr. Walia said that it would make Mr. Walia and the first claimant look good in front of the bank if the first claimant was continuing to invest money. The first claimant told me, it said to Mr. Walia that if he had 10 million, he was happy to invest it with the bank, Sarasin. The first claimant did not mention to me there was a collateral shortfall or margin call of the accounts. And then dropping down to 38 is what the first claimant said in his trial witness statement in the previous proceedings. Of course, these are matters he knew all along. In around mid-August, Mr. Walia called me on the phone. He asked me whether I was willing to invest a further 10 million. He said it would make him look good in front of the bank if I was continuing to invest money. He also said that it would be good generally for my relationship with the bank and would show I was a special client. Since I had not used all of the 35 million, I was happy to put some of that money back into Bank Sarasin. Told Mr. Walia I would do so. I understand the defendants now realize the purpose of this call was to discuss a collateral shortfall in the account and to call for a margin. I did not know what margin was until the bank made a margin call in September 2008, so I dispute there was any mention of a collateral shortfall or margin at this point. If I had been aware there was a collateral shortfall in the account in August 07, there's no way I would have agreed to leverage further the Bank Sarasin. Instead, I would have used the 10 million to pay some of the lending and reduce the risk of future collateral shortfalls, and I would have complained. And he says at the end, as a result of early closure of our investments, my mother and I had insufficient funds in order to repay the ABK loans. As a result, we've both become involved in litigation in Kuwait, and we have suffered substantial losses. So that's what Mr. Walia's and Mr. Noura's evidence, and there was a certain amount of corroboration from Mr. Taha, the accountant, in paragraph 37 there, in his witness statement, said this: I understand the first defendant's internal documents suggest I had a call with Mr. Nair, having worked with Mr. Blond and Mr. Khorafi in mid-August about a margin call. I was not involved in any such call. There was no suggestion at the time there was any margin call on the account. So as far as the accountant's concerned, that awareness alleged in the first defendant's offence did not happen, and there was no suggestion of a margin call. So all the elements were within their knowledge. First of all, the discussion from Mr. Walia had said was, it's to make you look good in front of the bank, to show you're a special client, no mention of a collateral shortfall. All the elements are there within their knowledge. And they, of course, know that a contrary case is put in the bank's pleadings. And Mr. Walia, at the same time, has, unsurprisingly, in his witness statement, served 4th of April, explained he explained to the claimant that there was a collateral shortfall and that it needed to be resolved. And in the same witness statement, if you go over the page, paragraph 40, Mr. Abbott cites Mr. Walia's witness statement for trial, served 4th of April 2013, where he says, quoting, he says, the position of the accounts was brought to the attention of Mr. Taha in the telephone call on the 15th of August with Mr. Blond, which is, of course, the position taken in the first defendant's defence. In late August, I also met with Mr. Khorafi in London in a hotel in the West End to discuss the margin call. I explained the position and performance of the portfolio and told him the value of the products was declining, which meant there was a collateral shortfall in the account that needed to be rectified with the deposit of additional funds. Khorafi did not express any surprise or confusion when I told him margin calls were made on the account. Indeed, a few days following this meeting, the sum of 10 million was received on Mr. Khorafi's account in Switzerland. He adds about the awareness of the account statements. As to the role of the statement in the first proceedings, my lord. When it came to trial, in the trial opening, Mr. Hill QC for the claimants actually identified this statement as a misrepresentation. That's back in bundle 4. I think you also put one to the side for a moment. Back in bundle 4, we see the opening, the trial opening behind tab 63. So the opening, this is the 19th of May of 2013, the opening of trial, and at page 2063, we see Mr. Hill making a submission from line 7, where he says this: I mentioned earlier that these investments were so risky they were likely to go into margin call in very short order, and that's exactly what happened. They're in margin call by August, the very next month. And very oddly, the margin call was in fact misrepresented to Mr. Khorafi. What was put to him was that he was being asked to invest a further 10 million rather than in fact paying 10 million as margin cover. So he puts it that it was a misrepresentation to the court. And my friend in his skeleton refers to line 21 also, where Mr. Hill makes a comment, if it really was a margin payment, in line 21, to say, well, it's a little bit more equivocal. Well, Mr. Hill obviously felt able to make the submission to the court that this was a misrepresentation, and we are dealing here with what claims the claimants could have made, and we say should have made, and we see on this page that leading counsel saying it was a misrepresentation. And my lord, in fact, even if they were unsure if there had been a margin call actually made, that's not the point, because their deceit case is not that a margin call was actually made in August 2007. Their case is that Mr. Walia lied about the purpose of paying 10 million, and so in fact he did not want to reveal that there was a collateral shortfall, and did not want to tell the first claimant that there was a margin call, but the monies, he gave a false reason, and the monies were actually used to correct a margin deficiency, but Mr. Walia wanted to conceal that. So their case is not dependent on whether the bank formally made a margin call or not. Their case is that you lied about the reason to get us to pay this money, which you in fact used for margin. And they knew all of that well in advance of trial, was certainly sufficient to plead that matter out. And the idea that with the claimant's evidence, Mr. Taha, the accountant, Mr. Taha, and Mr. Noor corroborating, Mr. Noor, who had apparently heard one end of the conversation in August 2007, the idea that anyone would have been criticised for making that pleading at the time is somewhat fanciful. And what of course then happened, my lord, is that there was cross-examination of Mr. Walia on the subject. I won't go there, but that cross-examination of course gave the claimants the chance to have, it now seems, a free run at Mr. Walia over the August 2007 statement, in circumstances in which neither defendant understood or appreciated that it had a much greater significance than would have appeared at the time, namely that it would be used in future to claim 30 times the size of losses than the 35 million compensatory damages that we were visited with, and 13 times in the first defendant's case. In the cross-examination of Mr. Walia, first defendant's employee, as per the written opening, the oral opening, Mr. Hill, for the claimants, did not consider himself hamstrung at putting the allegation that Mr. Walia had lied. And one sees that from bundle 6, tab 68. said I wasn't going to go there, sorry, but I didn't realise my whole one reference in my notes that I needed to go through. My apologies. It's tab 60, bundle 6, tab 68, page 2969. It starts where 2969.
Okay.
And this is Mr. Wally being cross-examined. And Mr. Hill, at the foot of the page, line 24, says that the reason I suggest you dealt with it in this informal way, which apart from anything else may have led to this difference of opinion, rather than using documentation, is because you did not want to actually call margin and notify Al-Kharafi there were problems with the transaction that had just been taken out the previous month. And he says that's not correct before the bank actually issues a formal margin call after they speak to the relationship manager who's handling the account and telling them to inform the client, and normally the client will then get the money in the next 5 to 7 days. But at the top of the page, Mr. Hill is putting that you didn't want to call margin because you didn't want to alert Mr. Al-Kharafi to the problem in the transactions, that there was a margin of collateral deficiency. So it's effectively saying you deliberately refrained from telling him it was a margin call. My Lord, and in particular, there's nothing in this cross-examination, I'm sure you pointed out to me there is, which created a light bulb moment on the part of the claimants to think, oh, we can actually plead fraud now in relation to this stuff. And if you look at the way, if we go back to Bundle 1, to the particulars of claim as they are now put, and you look at the pleading of dishonesty in the current action, which is in particulars of claim between paragraphs 65 to 75. You start at bundle page 36.
Hang on, bundle 1.
Bundle 1, tab 5. I'll look back in the particulars for the current action.
Yeah.
And the pleading of fraud, of dishonesty in relation to the statement is between paragraphs 65 and 75. And I'm not going to read them all out, my Lord, but none of those matters emerged in the course of Mr. Walio's cross-examination, and they all could have been pleaded in advance in the 2009 proceedings. And the idea that the pleader would have been criticised for pleading those, if they can plead them now, they can plead them then, because their information didn't change as a result of Mr. Walio's cross-examination. There's a final point, my Lord, before I leave the question of the role of the deceit, of the statement in the first action, the August statement in the first action, and it's this that a point is also taken in my friend Skeleton about agency and authority of Mr. Walio, because I think the argument is made that the claimant's understanding of Mr. Walio as an actual authority from the second defendant, bearing in mind he's actually employing the first defendant, that his actual authority improved in the cross-examination. And I think the reliance is placed on that passage I just read, where Mr. Walio said that there was a practice whereby the Swiss bank would ask the relationship manager at the Dubai bank to alert the client to an immediate margin call before he actually issued a formal call letter. Now, as we pointed out in our skeleton, it was always the claimant's case during the 2009 proceedings that the second defendant was liable for all the acts complained of on the part of Mr. Walio and indeed Mr. Blonde, who was the sole point of contact and the interface, and there was no direct dealing with the second defendant. And I showed Your Lordship how that was put in the particulars of claim in the first action. And I just give Your Lordship one more reference and remind Your Lordship of the references we looked at. But the particulars of claim in the first action is back in Bundle 4, tab 57, where I think I already showed Your Lordship what is said at
Bundle 4.
Bundle 4, tab 57. I think I already showed Your Lordship what the attribution case was that was pleaded, was always their case in the 2009 proceedings. And that's at the foot of page 1683 you will see in the broad pleading which I read out before that they acted as our agent and that we're responsible for all the wrongs complained of, including fraudulent misrepresentations, which I then complained of in the next pages, as I showed you, Lordship, 1684 and 1685. So we're being, it is said, to be held liable for all of the acts of these two gentlemen, including fraudulent misrepresentations made. And the wide case on attribution is repeated at paragraph 129 on page 1691. It says we are agent, and so vicarious, liability as agent on agency basis in paragraph 129 of further transactions complained of in the particulars. And finally, at page 1694, you'll see at paragraph, as far as negligence is concerned, paragraph 136, sub 1, in the premises above, Sarasin Dubai under Mr. Wally and Mr. Blond provided services for Sarasin Switzerland under a Swiss financial advisory contract under a relationship of services and or acted as Sarasin Switzerland's agent in relation to the transactions complained of in the particulars of point. And that's the same case that they are making in the current proceedings, because if your Lordship wants to compare that to what is said in the current particulars of claim, that is back in bundle 1. I'm sorry, I've got two files open. That's back in bundle 1 at tab 5 at paragraph 11. Where page 20 of the bundle, tab 5, it said that the Swiss bank, second defendant, is vicariously liable and directly liable for the secret statement and replied to secret representations made by Mr. Valier as its agent and the losses flowing therefrom. And in their particulars, in fact, their particulars, which are like tab 7 of bundle 1, they actually go so far as to say that attribution, so far as ostensible authority is concerned, is a matter of res judicata. They say that they go that far. They say at pages 93 to 94 of the bundle, behind tab 7, in response to a request by us at response 26 at the foot of the page, they say that the first defendant's act, that's Bank Sarasin Alpin's actual under ostensible authority extended to all matters connected to the provision of advice and information about the notes generally by its employees and agents, including Mr. Long and Mr. Wallier. The manner in which the ostensible authority arose is res judicata from the claimants and the second defendants as a result of the liability judgment. So it's the same case they always made. They're saying it's the same case because they're saying it's res judicata. And so it's the same case they always made, and they were quite happy to plead vicarious liability for fraud in the first action on a wide basis. So the practice of which Mr. Wallier gave evidence is barely relevant to the matter, and it's not pleaded anywhere as a matter that's relevant to authority. In any event, it's not actually alleged that Mr. Wallier was instructed to or did make a margin call. So it's not a question of whether he actually had authority to make the margin call, because the allegation is that he lied. He made a misrepresentation about the purpose of the 10 million payment to disguise the fact that the collateral was needed. So this is all a red herring, frankly. So to revert, my lord, to the chronology of the original action. Of course, after all that evidence in the given trial, which I showed you lordship a moment ago, I'm showing you all of it, of course. Deputy Chief Justice Chadwick made detailed findings at first instance about the statement. And for your lordship's note, I can go there if your lordship would like, but he deals with it in several paragraphs. His liability judgment is in bundle 8. Perhaps I just show it to your lordship without reading it. It's in bundle 8, tab 75, which is his long liability judgment after the original trial. And he deals with the chronology of the events over this period in some detail, as your lordship will recall. But in particular, he addresses it from paragraph 127 onwards, foot of page 3924. It's headed Events Leading to the Purchase of the Notes by Mrs. Al-Rafai in January 2018. Foot of page 3924, my lord.
Yeah.
So he's dealing with the passage of time from July 2007 leading up to when the third claimant invested in some notes in early 2008. And he really deals with the statement between paragraphs 130 to 133, which I won't read out, but he deals with the exchanges in August in some detail in 130 to 133, which Your Lordship can read it at leisure. That's how Your Lordship wants to spend his leisure time. And he makes some findings about that between paragraphs 207 to 212, which is on page 3954, where Your Lordship will see the heading, the telephone call on 15 August 2007. So it's right in there, even gets the same heading. And we get detailed a review of the evidence, and we see that when he sets out what Mr. Walia said, neither Mr. Taha or Mr. Khorafi accepted that there was a conference call, and then he sets out at 2:10 the first claimant's evidence, and he says at the end of 2:10, this evidence was not challenged in cross-examination. And then 2:11, he deals with Mr. Durr's evidence, the office manager's evidence. He had overheard part of the conversation, and he says at the end of 2:11, this evidence was not challenged in cross-examination. And on the basis of that evidence, I'm satisfied there was no conference call. That Mr. Blonde called neither Mr. Taha or Mr. Khorafi individually. That Mr. Walia called the first claimant. There was no mention of collateral shortfall, and the payment of 10 million was made for the reasons the first claimant gave. Now, and of course, Your Lordship may remember that Your Lordship actually recorded this episode in one of his judgments in the Court of Appeal as well. Your Lordship in necessarily less detail because it wasn't. Your Lordship was not the primary finder of fact. But in Model 10 at 101, Your Lordship dealt with the matter in the Court of Appeal in the judgments on 3rd of March 2016, and this was at page 4954, where Your Lordship deals with these events, recites these events in the passage between 142, paragraph 142, and 144. And Your Lordship makes some comments about it, about there being no evidence of a conference call in 143, and reciting what the judge found about it in 144. Now, it was absolutely part of the subject matter of the first action, and the idea that there was not that anything happened during Mr. Walia's cross-examination to create some kind of light bulb moment, and now we could magically plead dishonesty in relation to that statement. They had no new information at that time. If they could have pleaded it before, now they could plead it before. And which brings me to the real estate losses, my lord. Now, in the claimant's skeleton, my lord, the paragraph 56, they concede that the first claimant knew about the losses, they say, which are recoverable under the new claim before the 2013 trial. That's paragraph 56 of their skeleton. Now, they then go on to say the claimants couldn't form a view about these or plead them out. is what they say, and there are a number of points made about the losses not having crystallized or finally crystallized, in the expressions that are used. And essentially, to summarize what is put, it said that for the Al Khorafi Tower loss, it didn't crystallize until a sale under court execution process at auction of the only partly built tower in June of 2014. And it's on the Al Salmiya project losses, it finally crystallized, quote, when Mr. Al Khorafi, the first claimant's father-in-law, who had already terminated his son-in-law's development contract back in April of 2010, when the father-in-law finally concluded an agreement with a third party to develop the site. And it said, in respect of Iraq, the RAK losses, that's the losses on this planned share placement, which constitutes a large part of the $1 billion claim. It said those finally crystallized when the prospect of a further business sale agreement was extinguished, and they say effectively that was when the two other property projects finally failed. Now, as to take each of those heads of loss, the Al Khorafi Tower losses, we have in our skeleton at paragraph 51, if your Lordship are able to go there, which will save your Lordship having to take a note of any of this. We've set out in paragraph 51 the chronology of the tower losses as they appear from the claimant's own particulars of claim. So these dates and events are all taken from the claimant's own particulars in this action. And you will see that in the subparagraphs that Rafco, his property company, defaulted on its borrowings to the ABK in June of 2009. There's a July date given elsewhere, but it's either June or July. There was a default. And I'm not going to run through the particulars because they're all summarized here. Then ABK attaches his bank accounts as guarantor on the 1st of November. ABK calls in all the Rafco borrowings on the 10th of November 2009, issues proceedings against Rafco and the first claimant on the 10th of November 2009. Construction of the Al Khorafi Tower was halted at the end of 2009. The structure only 5 floors in height. Then the bank attaches his dividend earnings in July 2010 over the page at the top of page 17. October 2010, they actually asked the court, the bank actually asked the court, ABK, asked the court to open an execution file as a prerequisite to the sale of the tower and other property. Then the court appoints an expert who prepares a report 10th June 2012. The report was prepared on the 10th of June 2012. There's an evaluation presented to the court January 2013. And the court orders a sale of the tower on the 10th of January 2013. And we know the trial in the first action was in May of 2013. And there are two events which post-date trial. There is the actual sale on the 12th of June 2014, and there is the determination of how much was actually owed to ABK, the final assessment of how much was actually owed to ABK. Those are the only two events which post-date the trial. Now, if you were looking at a limitation point, we'll come to that, that's our fallback position, is that the negligence claims are statute barred anyway, but that's our fallback position. But the fraud claim is under DIFC law would be evergreen. If you were dealing with a limitation point on a negligence claim, and you were looking at when did Mr. Al Khorafi suffer a non-trivial measurable loss, then it's right back in 2009, because That's when his property company defaulted and ABK attaches his bank account as guarantor and files an execution case for $34 million. And at the end of 2009, the actual construction is halted. So obviously by the end of 2009, he has suffered significant loss in relation to the Al Khorafi Tower project. Now we are, and in fact, one's not dealing on the abuse application, one's not dealing with a limitation view. One is dealing with a broader merits-based assessment of whether there's an abuse going on here. But I do want to show you, Lordship, one matter that is asserted in the current particulars of claim back in file 1 at tab 5, where at paragraph 117, which is page, I haven't got the page right, it is page 47. Page 47. This is the claim, that's particulars of claim that we're facing in the new action. Well, this is stuff. It only became clear to Mr. Al Khorafi in mid to late 2008 that the second defendant would not be advancing further monies for RAC, as Mr. Wali had previously indicated they would, and instead the investment centre with Bank of Cyprus House and the second defendant were in significant difficulties, which would leave the claimants exposed on the lending they'd taken from ABK to fund the investments. Mr. Al Khorafi warned Mr. Walia and the second defendant that this would have serious implications for Rafed, that's his property company, and its projects, inter alia at a meeting which took place in Nice, France on the 22nd of August 2008 between Mr. Al Khorafi, Mr. Noor, Dana Thabara, and HSBC representative Rohit Walia, and Mr. Blonde on behalf of the defendants. Said meaning a margin payment was requested. So as early as August 2008, he is saying, you have caused me problems with my property projects. As early as that. Now, bearing in mind, my lord, that the 2009 proceedings were claiming losses on a no transaction basis, that is to say, the complaint was to be compensated, the complaint should embrace all losses which would not have been suffered but for the purchase of the notes. Clearly, these losses should have been claimed at an early stage. And just to make good the point, my lord, that the proceedings were brought on that basis. If your lordship can put away bundle 1, your lordship will need, first of all, bundle 2 and then bundle 4 of these products. I'll go to the letter before action in the 2009 proceedings because there's a bit of a quibble about what it said, so I'll just read it in this regard so that your lordship sees it. It's bundle 2, tab 38, and this is the letter before action in the 2009 proceedings. Bundle page 733, paragraph 114 of this letter. The lawyers then acting for Evershed, then acting for the claimant, said this: by reason of these matters set out above, our clients are entitled to claim against the two defendants to recover all of their losses and to be put back in the situation that they would have been had none of the investments been undertaken. And when it came to what was put at trial, your lordship will find the opening written submissions of the claimants in the trial in model 4, tab 60. And it's at paragraph 184, page 1871, almost page 1871. Where one sees at paragraph 184, under the heading of the relief sought, this is their opening at trial, the claimants are simply looking to be put back in the position they would have been if they had not entered their investments with the second defendant. And finally, on that point, my Lord, there's one other reference, which is that was confirmed in a later skeleton argument relating to the appeal we talked about a little before, the attempted appeal against the refusal to admit the tower losses later on, and that's in London 10, behind 95. If you look at page 4760, there, 4760 has paragraph 29. We looked at this for another purpose a moment ago, but there's another point from this paragraph.
So 4760.
4760.
Okay.
4760. And it said, the first part of this paragraph, the first claim, paragraph 29, my Lord, the first claimant's case is straightforward. The claimants have always pursued their losses against the defendants on a no transaction basis, as the judgment from the trial recognises. In other words, they should have been entitled to compensation for any losses they have incurred, which would not have been suffered but for the defendant's breaches in relation to the Sarasin investments. So, and of course, as I showed you before, the first claimant's own case is that his property losses were caused by his investments in the notes with Bank Sarasin. That's his case. So you've got this multi-million-dollar claim going on in the 2009 proceedings against these defendants, all manner of causes of action pursued, claiming on a no transaction basis all the losses suffered by reason of the notes investment. And the claimant knows since 2009 he suffered loss on his Al Khorafi Tower, he says, investments, since 2009. And in fact, by early 2013, 10th of January, he knows that the court's actually ordered a sale by auction, a forced sale by auction, of a partly built tower, it's only 5 stories high, which was supposed to have been completed long before. But he doesn't raise any of this. He doesn't raise it before trial, and in fact, the first time he tries to raise the Al Khorafi losses is over a year later, after trial, when it's put in evidence in November 2014, and at that stage it is rejected. Of course, what the ALDI guidelines say is that these matters should have been raised at an early stage so they could be properly case managed. And I'll come to the ALDI guidelines in a moment, we'll deal with the law. But it's a similar story on the Al Salmiya losses, my lord. We have in our skeleton, given the chronology similarly for those, at paragraph 57 on page 20. One sees, again, this is from the claimant's pleaded case in the current action. So this is the claimant's case. That funding was suspended from around June 2009. That Rafco and the claimants failed to pay his father-in-law, the landlord, to the default with the landlord of the site in 2009. In April 2010, the father-in-law learns about the action that ABK is taking. The ABK Rafco loan has been cancelled, and ABK is seeking to enforce. And on the 4th of April 2010, the father-in-law gives a notice to terminate the development agreement for the site. And then it terminates on the 11th of April 2010. And all of that years before trial in the 2009 proceedings. In fact, more than 3 years before trial. And then the only thing that happened later is around 2014, the first claimant's father-in-law concludes an agreement with someone else. Now, you can make, with damages, you can make all these sort of speculative suggestions that A, B, or C might have happened to save the day. But frankly, in this case, you do not get away from the fact that a tangible loss has been incurred from as early as 2009. The damages can be different. It's perfectly possible that unforeseen things happen down the line to remedy your position and to improve your position, but have you suffered a tangible loss in 2009? Of course you have. Now, as to the RAC losses, the share placement, if your Lordship would take out bundle 1, your Lordship will see that in tab 7 we asked some questions about this in our request for particulars, and in bundle 1 behind tab 7 at bundle page 102 we get there was in response to our request number 50, we get a response at the top of page 102 under responses number 50. The plan to make a public offering of RAC shares was abandoned in around late 2011, leading to its delisting on the 5th of July 2012. Actually, an earlier date for the delisting is given in the particulars of claim. The particulars of claim at paragraph 105 say the delisting was on the 19th of March 2012. So it's either March or July 2012, but it's obviously quite a long way before trial, and well over a year before trial. Yes, and while we're on that page, in response 51, just picking it up 5 lines in, same page 102, as pleaded in paragraph 101 particulars of claim, the Al Samir project was terminated in April 2010. As pleaded in paragraph 90, on 12th October 2011, the Kuwaiti court opened an execution file in relation to Rafco's assets, including the Sharik plot and the tower. Accordingly, by late 2011, it was apparent RAF could not make a successful public offering, given the Rafco project could not at that point proceed. Could not at that point proceed. It was in these circumstances that in order to save the ongoing fees and costs associated with being listed in the London Plus market, the decision was taken to delist RAC. Even if, my Lord, there was some uncertainty about the final quantum of losses, as there very often is in litigation, very often, that does not justify holding back the claim for this head of loss. Damages can be difficult, and the court does the best it can. And it may have given, and we can discuss what procedural directions when we come to the ALDI decision that might or might not have been given to deal with these losses, but it did not excuse the failure to bring the losses, the claims for the losses. In fact, if you look, and I think perhaps this would be a valuable exercise, if your Lordship goes back to the particulars of claim, so it's still in bundle 1, I hope your Lordship didn't put it away optimistically, but in bundle 1, tab 5, the particulars of claim we now face, if you look at schedule 1, which is the particulars of loss, bundle page 59 onwards, we have all these losses, and we've given all the references to this in paragraph 55 on page 18 of our skeleton. All the losses claimed in this schedule could have been quantified by 2012. Almost all of them are based on documentation dated between 2008 and 2012. So, essentially, the claimants could even have quantified their losses in 2012, and not bringing the heads of loss forward in the circumstances was plainly abusive. And the claimant skeleton, paragraph 60, says, well, the losses were a bit incurred and we couldn't make a fair assessment of them. Well, actually, they could. In fact, by 2012, they pretty much knew what the losses were.
I can give the short-hand riders a short break now.
Of course, my Lord, yes.
I've got a meeting, I'm afraid, at 4:45, so we're going to have to rise then. And I'll consider what we're going to do in terms of time tomorrow. Okay, thank you very much.
Thank you, my Lord.
All right.
How long will the council be attending?
Sorry, I'm having difficult. Are you off? Are you off? The judge is coming back. Just I think so.
Have you seen his idea from Somalia?
I guess I'm not sure what this is. So how do I look
I believe so.
Okay.
All rise.
Yes.
My Lord, I was going to move to the next reason that is put forward for not bringing these claims, which we say obviously belonged in the 2009 proceedings. That reason being that it said that the claimants were unable to fund those claims. Now, just to put the relevance of, or potential relevance, if any, of that in its context, if I can invite the Lordship to take up our authorities example, and just to look again at Johnson and Gore Wood behind tab 11. We looked at this page briefly before, it's on board page 134. And there is reference, excuse me, to this just by letter E on the page, where Lord Bingham says this just about letter E. Thus, while I would accept that lack of funds would not ordinarily excuse a failure to raise in earlier proceedings, an issue which could and should have been raised then, I would not regard it as necessarily irrelevant, particularly if it appears that the lack of funds has been caused by the party against whom it's sought to claim. While the result may often be the same, it is mildly preferable to ask whether in all circumstances the party's conduct is an abuse, rather than to ask whether the conduct is an abuse, and then if it is, to ask whether the abuse is excused or justified by special circumstances properly applied, and whether the legitimacy of this set of rules, in my view, are vulnerable part to play. The rule having been described in the well-known passage above. Now, so Lord Bingham says it would not ordinarily excuse failure to bring a claim, but it's not necessarily irrelevant, particularly if it appears that the lack of funds has been caused by the defendant, which is something that's asserted in the claimant's skeleton here, but is quite obviously not the position on the evidence. Now, I should just, as an introduction to this point, note for your lordship that what we're talking about here is funding the additional legal costs of making or pursuing some further claims within the 2009 proceedings. And in that context, where the claimants were, of course, already spending significant funds, with legal team already on board, very familiar with the context, the background, the documents, and so on. So it's not, of course, the same as the costs of pursuing a new standalone 2016 action. You don't have the economies of trying the claims together and so forth. And you probably need personnel in any event. But the claimants in this case have not sought to assist your lordship with estimates of costs for that purpose. But that's what we're looking at. So one would be likely to be talking of costs perhaps in the order of $1 million or so, maybe in the hundreds of thousands of dollars, which would have had to have been incurred between 2011 and 2012, and these claims should have been included. Now,
sorry, can I just get a slightly more precise figure on that? When are you saying that these additional claims should have been pleaded?
Well, they should have been pleaded by the very latest by the middle of 2012. And probably before, in fact, because most of the information was available even before that.
Okay.
Sorry, I think Ms. Bingham is quite right to alert me to that, to qualify that, because that's. Sorry, would you want to just give me one moment?
Yeah.
And your lordship has the point that to claim these heads of loss, that there's no need even to be able to be in a position to plead deceit. I think I've perhaps laboured that point a little bit too much. So even if your lordship were to take the point that, and we think this is not right, that a pleading in deceit would only be legitimate later on, certainly the heads of loss could and should have been claimed by the latest, the middle of 2012.
Okay.
I'll come to this, but insofar as adding a claim in deceit is concerned, given that the statement was already very much part of the subject matter of the first action, that statement in August 2007, and there had been witness statements on it, there had been disclosure on it, there had been pleadings on it, as I showed you, Lordship, that could even have been introduced quite late on in the day, because it would not have particularly added to the factual inquiry, because it was already in there. So even if the materials to plead deceit had come later, which we don't think they did, that there would have been not been a struggle to accommodate that even quite close to trial. Now, my Lord, so what we're talking about here is funding of additional heads of loss, and what would have frankly have been the very modest amount required to fund the claim in deceit, given that it was already subject of evidence disclosure, etc., etc. So the bulk of any additional costs would have been costs of the real estate losses, proving causation and the real estate losses. Now, I need to show you, Lordship, the evidence which we cite in our skeleton between paragraphs 69 and 72, which comes from November 2014. This is, my Lord, these are in bundle 9, and these are, this is evidence filed on the claimant's behalf after, more than a year after trial. It relates to their financial position. It's more than a year after trial, and so November 2014, and after, according to the claimant's skeleton, paragraph 6, we are supposed to have, and I quote, caused financial disaster to the Al Khorafi family by the investments. So we're after the time where we should have apparently caused financial disaster. And we actually see quite obviously that was not so. Bundle 9 at tab 79, my Lord, first of all. The context for this evidence, my Lord, is this is a witness statement of Galen Hanlon, a solicitor for the claimants, in November of 2012, 12th November 2014, beg your pardon, I misspoke, 12th November 2014. And the context is that it was made on behalf of all three claimants. You'll see that from the foot of page 423. And it was in the context of the defendant's application to stay the order of Mr. Justice Chadwick made in October, ordering them to pay money, 28th of October 2014. That was the Deputy Chief Justice Chadwick's order after trial, ordering the defendants to pay money, and this evidence was made in relation to that because the defendants asked to stay that order, and this was made in response to that, to resist the application to stay. And I want to show you, Lordship, paragraph 8 on page 4235, where...
This one now, what, for a stay pending the appeal? Or?
Yes,
yeah.
yes,
Okay.
yes. And at 4235, on behalf of all the claimants, this is said: the claimants are people of substance. Indeed, Deputy Chief Justice Chadwick found that all were wealthy, quotes the judgment, in particular the second defendant, who inherited substantial wealth from her husband and family. The question for the court is whether the defendants are exposed to irremediable harm if they make payments in accordance with the order. Given that in excess of 8.5 million of the sums payable are due to the second claimant, it's appropriate for the court to focus on her position primarily. She is the wealthiest of the three and has very substantial property assets in Kuwait. There is a reciprocal enforcement agreement between the UAE and Kuwait, and the State of Kuwait has ratified 2 multilateral treaties in this regard, and she refers to them. The defendants would have no issue enforcing any order made against the second claimant in Kuwait. The first and third claimants are also people of substance, as the judge found. There's no reason to assume that they would not be able to meet any adverse order against them. The amounts envisaged, 1.5 million for the first claimant, 1.5 million for the third. In those circumstances, there is no risk of irremediable harm to the defendants. Now, the submissions made to the court that went with that to resist the stay are behind the next tab, tab 80. These are the claimant's submissions on resisting the stay, which are signed on page 4238 by counsel, or in the name of counsel, and in paragraph 6, on page 4238, they say this: it should be particularly noted that the second claimant is extremely wealthy, and it would be profoundly unfair if she was deprived of her judgment on account of the alleged inability to repay in circumstances where her net wealth is many multiples of the judgment sum. The material produced by the defendants on their application does not begin to justify such an outcome. And there is a further witness statement behind the next tab, tab 81, by Ms. Hanlon, again on behalf of all the claimants, where it was sworn around the same time, 17th November 2014 in this case, where at paragraph 1.2c on page 4240, she says the following, letter C: notwithstanding the matters set out above, including the foreclosures and personal guarantees, 1, the first claimant is a businessman with substantial assets, and his net asset position is substantially above the amount of 1.28 million, which is due under the order of the 28th of October, if that sum ever has to be repaid. 2, the second claimant has very substantial assets, including unencumbered personal and real property assets. Her net assets are in excess of $70 million. Her net asset position is substantially above the amount of 8.5 million, which is due under the order of the 28th of October, if that's something that had to be repaid. 3, while the third claimant does not have a net asset position of the size of the first and second claimant, as the spouse of the first claimant, she still has available to her more than sufficient assets available to cover the amount of 641,000 she's due under the order, if that sum ever had to be repaid. So that's more than a year after the trial. And we got a little bit more insight, my lord, because just 7 days after Mr. Justice Chadwick gave judgment following trial, he gave judgment on the 14th of August 2014, his long liability judgment. Just 7 days after that, the claimants terminated their solicitor's retainer, KBH's retainer, and appointed their current solicitors. The reason we know this is from a judgment of Sir Richard Field in the dispute that Mr. Khorafi had with Vannon, the litigation funders. But that's, I won't go there, it's behind, it's in bundle 10, tab 102. But to summarise, my lord, Vannon's litigation funding arrangement gave them the right to have recoveries from the defendants paid into KBH's, the solicitor's account, and Vannon would have a first call on those monies. And there was concern that the claimants would not pay the money into the solicitor's account, and that the new lawyers would not agree to an escrow proposal. And the result of that was that Vannon first and then KBH both applied for protective orders.
Sorry, I have to say that again, I couldn't hear.
Vannon first, the litigation funders, and then KBH, the claimant's previous solicitors, both applied to the court for a protective order such that the monies would be, paid into court in the end. And of that, the claimants disputed jurisdiction, funnily enough. But I tell you that, my lord, just to give you the context for the next matter I wanted to show you, Lordship. It's what Mr. Noor, the claimant's office manager, said at that time about his asset position. And in fact, having said I wasn't going to go to Sir Richard Field's judgment, that might actually be the easiest place to pick that up. And if your Lordship can, I think, put bundle 9 aside for the moment, if your Lordship would take up bundle 10, tab 102, this is the judgment of Sir Richard Field, which I mentioned a moment ago. In the Vannon matter. And he at bundle page 5038.
So divide
Divided 102, my lord. And at page 5038, he recites some of the history, which I won't read it all out because I've tried to summarise it for your lordship. But effectively, the question in issue was whether the first claimant could pay $2.5 million in legal costs to the solicitors, dollars, even if he lost the appeal. That was effectively the point in issue. And Mr. Noor had given some evidence in relation to that, and that is summarised in paragraph 43 through to page 5042, where the judge says this: briefly put, Vanens, that's the funder's case, in answer to the first application, was that properly analysed, it was an application based on financial need, in particular the need to pay debts already incurred in prosecuting the main action, especially counsel's fees. It was incumbent on the applicants to show that there had been a significant change in circumstances since.
So which paragraph are you
43, Ronald.
I've got it, yeah.
Yeah, and I'm just turning over to the top of 5043. I can pick it up there. The order made on 10th of November 2014, and this they failed to establish. Financial need had featured in the application heard on 6th November 2014, and the future legal costs were all too predictable. Moreover, there was no evidence that the Khorafis lacked the resources to pay the debts they faced. On the contrary, Mr. Noor made it plain in his witness statement that Mr. Khorafi had the means to pay the debts, even if the Khorafis lost the liability appeal. The only subsequent developments were the order of Justice Giles giving the Khorafis permission to appeal and making that permission conditional on payment into court for all future recoveries, both of which are highly likely events from Van's preservation application was heard. The amounts that Mr. Noor is saying that Mr. Khorafi will have no difficulty in paying, it's $2.5 million. You get that figure from paragraph 24 on page 5038, where it is cited. His unpaid debts are cited in the 6th line of paragraph 24, the 2.414 million. Now, so it would seem, the point of looking at this matter is that it would seem, in addition to the other materials I went to, that in a similar time frame, Mr. Noor is making evidence saying that Mr. Al-Khorafi would have no trouble paying $2.5 million to his lawyers, even if he lost the appeal. Now, the combined effect of this evidence, Mild, is the evidence I showed you before and what's said in this judgment, is that it points to the Al-Khorafi claimants having more than 72 million of assets, even after trial, which they could liquidate if necessary to raise up to 12 million, because if you remember the stay on this, resisting the stay, that's potentially what they would have to repay if the appeal went against them. So they're basically saying we could repay this money if we had to. So they are saying that our assets are liquid to that extent, or at least monies can be raised against them implicitly to that extent. And it's far from the case, as is presented in the Friend skeleton, that we had, quotes, caused the claimants financial disaster, because even after trial they're saying we've got plenty of money. We, far from causing them financial disaster, we don't even appear to be causing them to be pecunious in any way. Now, the claimants themselves, Michael, have chosen not to put in evidence of their asset position for the purposes of this application. That's despite the fact that we questioned them about that in our request for full information, because of course you logically appreciate that their asset position is relevant not just to this application, but to the substantive merits of the case made in the 2016 proceedings, because of course their causation case turns on saying my entire, being the first claimant, property empire collapsed because I paid 10 million in August 2007 to the second defendant. And that, for that hit worth of tar, as it were, the whole ship was lost. And I've got $1 billion loss as a result. Now, obviously a key part of that, the claimant will have to show that he could not have funded his loans from elsewhere, and that the 10 million was absolutely key to him not going into default in his property empire. So his assets were squarely, and are squarely an issue on the substantive causation issues of the current action. Back in bundle 1 behind tab 6. And I won't read all these requests, but that's our request for further information. It's very much you'll find it. We asked a lot of questions about the Khorafi's asset position and the extent and the liquidity, the types of assets they held and at different times, including July 2011. And each one of those requests was stonewalled. We didn't get an answer to it. And the requests, just for your logic to note, that were asked about assets are requests 20 to 24, 47 to 49, and 55 to 68, which we're all told in respect of all of those by the run out. And as I say, in our submission, they were justified in relation to the substantive dispute and also in relation to the application to strike out for abuse. And in the context of this application, in the same bundle, your Lordship will note that in correspondence behind tab 21, Clifford Chance wrote on this subject, page 247. There's a letter that starts 246, 10th of January this year. 246.
Yeah.
And the Clifford Chance refer to this at the top of page 247. Our client has repeatedly sought to understand your client's financial position, both in the course of the 2009 proceedings and the current proceedings, in requests, and they're listed there, of our request for further information. Your clients, and this was a request back in March 2017, your clients were invited to explain their financial affairs. However, you've chosen not to respond to these requests, which are also plainly relevant in the context of the present application. It's consistent with your client's repeated failure to disclose information relating to their financial affairs in the 2009 proceedings. In the light of the above, it's clear your clients have failed to discharge their burden of proof, and in this regard, we will also refer the court to your client's continuing failure to respond adequately or at all to our legitimate request for information relating to their financial position. The reference to burden of proof is this one. I don't dispute for a moment that the overarching burden of proving an abuse is on us, is on the second defendant on this application. But if there is an evidential matter that one party wants to rely on, they must bear an evidential burden of showing or bringing forward evidence on that issue. And that would be the case in relation to an assertion that the Khorafis had been ruined and could not possibly have financed further claims in the 2009 proceedings in the time frame that we have talked about. Now,
what are your costs so far in these proceedings?
I'd have to take instructions on that. Can I find out overnight?
Yes.
Can I? I'm obliged.
I'd like to know from both sides the answer.
Yes. The claimant's skeleton on this question says that they didn't have to answer those requests because they were in accordance with the rules. On that, and they cite the Day1 case in this jurisdiction decision of the Chief Justice Wang, which is a decision, I'm not going to go there, that it basically deals with the usual debate about, the familiar debate I should say, about the balance to be struck between giving fair notice of your case and making excessive demands for endless particulars. Depending on what the facts are of any individual case, you can debate whether their request falls on one side of the line or the other side, as your Lordship knows. But here we had legitimate requests, both in relation to the substantive case and on the abuse application. And even if it were arguable that some of those requests were too much, too detailed, or whatever, the decision not to give any particulars of their finances in the context of this case and with this application is in my submission revealing. Now, the involvement of Vannon, which I should deal with, does not, the litigation funder, does not, in my submission, assist the claimants at all. I don't know how familiar your Lordship is with the use of litigation funding, but certainly the use of a litigation funder, in my submission, tells you nothing about the claimant's finances, because it certainly doesn't mean you're impecunious per se, because of course people use litigation funding also because they don't want to tie their own money up in a project with an uncertain outcome over an uncertain period of time. So the fact that you choose to use a litigation funder doesn't tell you and isn't evidence that you can't pay your legal fees. It might be the case, but it's not a conclusion that the court can draw. Now, the other points to note about Vannon are, first of all, that under their litigation funding agreement, as you would expect, they were not entitled to interfere with or manage the litigation. Because that's also a core principle of the Association of Litigation Funders. But their litigation funding agreement is in Bundle 3 at tab 47. And this particular clause is at page 1102, which is clause 23, heading the funder's responsibilities. And this is the original funding agreement. It's unchanged in the amended version. It says, at clause 23.2, the funders must not in any way interfere with, meddle in, or try to influence the claim in any way other than to ensure the terms of this agreement are being respected, and to ensure the claim is adequately funded. That's exactly what you would expect, Michael, because Vannon is a funder member of ALF, the Association of Litigation Funders, which is an independent body charged by the Ministry of Justice in the UK with developing self-regulation of the litigation funding industry. And I'll just show you one of their core principles.
So, forgive me. This is dated January 2011.
Yes.
According to the chronology, the litigation funding agreement is dated January 2012.
My Lord, I think it's a mistake.
Which is wrongly dated.
My Lord, I think it was in 2012, so it's a mistake till 2011.
So the agreement was entered into in 2012.
Yeah, that's the agreed chronology.
Yes.
So it's the document, I think, being a mistake.
That's shortly after the jurisdictional appeal was dismissed.
I think that may be right. I haven't got the chronology. That sounds right.
Okay, thank you.
My Lord, the other matter, actually, while we're in this funding agreement, it will save time if I just show you, Lordship, the other clauses that may be of some relevance, because over the page at 1104, when it says further funding, clause 26,
Yeah.
it says this: the client hereby grants to the funders the exclusive right of first refusal to provide the additional funding on appropriate new terms, which may include enhanced premium and on terms no less favourable to the funder than those set out in the agreement. The client may require, with respect to the claim, the foregoing should not be deemed to impose an obligation on the funder to provide the additional funding. For the avoidance of doubt, 2, it is recorded the client not permitted to offer terms to another funder on more favourable terms than those offered to the funders, and nothing in this clause shall restrict the right of the client to borrow funds on commercial terms. Now I'll come to the significance of that in a moment, but just on the point of, there's an implication that Vannon would have stopped him making these claims. And as your Lordship sees from 23.2, Vannon wasn't contractually allowed to interfere in the conduct of the litigation. That's part of the code of conduct of the Association of Litigation Funders, as which Vannon was a visible member of. And you also get that code it's exhibited by Mr. Abbott, and it's in bundle 11 behind tab 189. This is the code of conduct of the Association of Litigation Funders in Wales, of which Vannon is a member. And it's 5157. I'm just going to show you, Lordship, what provision 7C says. That a funder will not seek to influence the litigants first to embarrass or to seek control or conduct of dispute to the funder. So, the origins of this, my Lord, I'm sure back in Champagne incidents and so on, but that's a core principle of the Association of Litigation Funders, that they fund but they don't interfere with the litigation. And the evidence in our case that we have does not in any way suggest that Vannon would have acted in breach of contract, the litigation funding agreement, or indeed in breach of their code of practice by interfering with the conduct of the litigation to stop the claimant bringing these claims if he chose to do so. The Vannon are accused in the threatened skeleton of being, I quote, extremely disruptive. That's paragraph 72 of the threatened skeleton. Now, that's completely unfair, my lord. What that judgment of Sir Richard Field that I went to a moment ago does show, and in fact, this is borne out with the other pieces of evidence, that what happened was that pre-trial, because Vannon got an opinion from Jeremy Cousins QC giving a low prospect of success on the merits, they insisted on having a revised funding agreement that was more favourable to Vannon. And pursuant to that, actually, the claimant put up another $350,000. He says that in his own evidence. Now, the relations with Vannon only deteriorated a year and a half later when, as I mentioned to you, Lordship, a moment ago, after trial, the claimants removed their solicitors and tried to engineer a position where the proceeds of the trial were not paid into an account with the solicitors on which Vannon would have the first call. And that's when relations deteriorated and it resulted in litigation between them. But Vannon, as far as we can see, behaved completely professionally throughout, and indeed particularly in the run-up to trial and during any period at which there might be an issue of whether hypothetically could the claimants have paid the fees of these new claims. Now, as to whether Vannon itself would have funded, we don't know, because it seems it was never asked. And it should, of course, the claimant should have been arranging to bring these new claims on the Johnson and Galwood principles and the ALDI guidelines. But instead, it seems that Vannon was never asked whether it would fund. Well, in fact, given that Vannon had, up to that point, invested about $3 million in a claim of $75 million, there's no other reason to think that they or some other litigation funder wouldn't be very interested indeed if, as the claimant says, he had a strong claim in fraud against the bank for $1 billion. Now, and even if Vannon had chosen not to fund they could not impede the claimants running the claim from their own resources, or even using another litigation funder or commercial lending, provided, as I showed you, Lordship, Vannon had the right of first refusal on the further funding. So, in short, Vannon couldn't impede the bringing of these claims. They might have funded it, but it seems they were never asked. And if they didn't, the claimants could have funded it from their own resources or raised the funds to do so commercially. Now, the final point to make on Vannon, my lord, is that It said O'Vannon wouldn't pay for the due diligence on the new claims, wouldn't have paid, it's all hypothetical, they were never asked, wouldn't have paid for the new due diligence on the new claims. Well, obviously on the evidence, participation in the litigation fund wasn't necessary at all for that purpose, because the claimants had assets. But in any event, Vannon weren't asked, and such evidence has been adduced through Mr. Abbott from the websites of the various ALF members, the Association of Litigation Fund of members, shows that the usual position is that the funders fund their own due diligence. I'll show you that briefly because it is of some relevance on this point. These are in bundle 11. The first one is behind tab 111. You have at tab 111 you have Harbour's. Harbour's a very well-known litigation funder in England.
Yeah.
And at 5180, they say in their material, in the middle of the page, under letter of intent, in the third line, during the period of exclusivity, we commit further internal and external resources to prepare for approval at no cost to the claimant. The redress solutions are behind tab 112, and at page 5187, item 3 towards the foot of the page, they say there's a 7-step process, and then a more detailed analysis at our expense begins. We may talk to your lawyers to estimate likely costs, for example, or determine if those costs are consistent with any likely awards. Woodford, these are all ALF members, my lord, and Woodford at 113, tab 113, page 5191. They refer in the middle of the page.
Anyway, these are other litigation funds, aren't they?
These are litigation funds. They're all members of the association.
Mr. Cousin was on the panel for that.
Right.
So we don't have a list of their panel.
I think we do have a list of ALF members. The point of great page 5191 was the middle of the page where they say there's a paragraph saying we offer claimants the use of these resources with our no-cost case assessment and structuring service. So the practice of funders, certainly the mainstream funders, seems to be that they will do the due diligence on pay for the due diligence on the claims element. And if you ask yourself what due diligence was required on the deceit claim, which was already part of the subject matter of the 2009 action, it can't have been very much additional due diligence. And when it comes to the real estate losses, as I showed your Lordship a moment ago, and is borne out by the reference, all the references to paragraph 55 of our skeleton, that by 2012, pretty much all of those losses could be quantified. Certainly, yes, it would have involved further funding, and it may have been significant funding, but in our submission, there's no indication in this case that the claimants were so pecunious they couldn't have undertaken that. In fact, when they came to try to bring the tower losses, as I told you long after trial, in November 2014, they actually had done the work, or some of the work, on the tower losses by then. They had paid for Grant Thornton to carry out some work on it. I should just show you, Lordship,
So before we do that, can I February 2013, the funding agreement with that terminated.
yes,
That's what, coincident with the provision of Mr. Cousins' opinion, or not?
well, it seems to have been around that time, and there was then.
So in the Van-in, well, I don't know if we have the Van-in documents here, but if they get a nasty opinion, they can terminate, can they?
Well, I think they reserve that right. Yes.
Can I just see that?
We'll find it, Your Lordship.
I've got harbour, I can see that. I mean, I'm not saying, I just want to see what van is.
No, no, 347. We'll just find out. 347. I've read it in other funding agreements, but I just didn't find it in this one. It's not uncommon.
Anyway, we haven't got it in there, is that right? Maybe it's here somewhere. Well, what about the code of conduct? Does that deal with this? I think it does. And it's slightly surprising if you can, you send a funding agreement, and presumably there's what I call a due diligence exercise, and somebody like Mr. Peter Rees QC is asked to express his view, and then you put up the money, and then very sadly, I don't know, Mr. Gordon Pollock comes along and says he doesn't think that's a good. Well, they can just pull the rug, can't
Well, before answering unequivocally to that, I'd like to find the clause.
they? Okay.
But Your Lordship, it's right to raise an eyebrow at that.
Well, I do raise a bit of an eyebrow, but is the cousin's opinion in the
Yeah, the reason we know
papers?
the effect of the cousin's opinion is because it's recited in the judgment of Sir Richard Field in the Vannon litigation.
When he saw it, then did he?
He obviously saw it. Well, or been told about it. He's recited. I'll show you much of that.
Yeah.
I should show you much of that. The
Thank you.
I think the code at 9 has something about this, which is back in bundle 11.
I've got
tab-
111 still open, yeah.
Yes, 109 at page, this time at page 51, tab 109.
I've got that, that's the code, yeah.
5158, that's code provision 9.
Thank you.
It's 47. And it says
Reasonably ceases to be satisfied.
about the merits of the dispute.
That's quite dangerous, isn't it? Oof.
Well,
Yes.
they've all signed up to this one. It's a burgeoning industry.
I wouldn't want to sit on that seat for long, I don't think.
Right.
Okay, right.
I'll,
No longer commercially viable.
Yeah.
Yes. Thank you.
Well, the funders would no doubt say that in some cases they're providing.
Anyway, you were going to show me the reference to Mr. Cousins' opinion.
Well, the reference to it. my lord.
There's no more than a reference to it.
Yes, I think we haven't got the opinion.
You haven't got the
I
opinion.
think we may have asked it, and we were refused on privilege grounds, but it's referred to in the judgment of Sir Richard Field, which I had a reference to a moment ago, but I lost it, of course.
Oh, don't worry. It probably
it's,
doesn't say any more than...
No, it's in bundle 10, tab 102.
Right. Yeah.
Find the reference to the opinion of Mr. Cousins is in paragraph 30 on page 5040.
Yeah.
Where it said Mr. Cousins' opinion was produced on or about the 20th of March, in which he added a further note, the 22nd of March. In Mr. Cousins' view, the Khorafi is no more than 25% chance of success
Yeah.
on this rep, and they're claiming the balance of liability no more than 40% chance. Bear in mind that it's now said with acquaintance that we shouldn't have defended this case. This Bingham has kindly found the provision in the LFA, the litigation funding agreement, which is 27.3 back on page 1104 of bundle 3. So it's bundle 3, tab 47.
Yeah.
And it's page 1104, foot of the page, clause 27.
Yeah,
Point
now.
3.
I've got it now, yeah.
Significant change in merits. Independent Queen's Counsel. Well,
Thank you
I
very
suppose it might be said that gives a certain level of protection, given that one has to get an independent Queen's Counsel opinion as far as that is concerned.
be a change then, isn't there? I suggest there's been an earlier opinion that things were better than this a bit. Yeah, okay. Right.
Well, things do change in the course of the engagement, because
Oh,
one gets
of course they do.
disclosure and one gets, and other things happen and information actually flows. So even certainly Queen's Council opinion wouldn't necessarily remain the same throughout the course.
Yeah.
And funders are obviously concerned and alive to that.
Okay.
I think I was almost finished the involvement of Vannon. I'm conscious of your Lordship's timetable today, but yes.
Your colleague will have to agree a split of time. We'll sit earlier tomorrow as you like, but I think I have to leave the building by, well, I'm guessing I have to check about 12:30. So you only got the morning.
I wasn't aware of that.
Oh, no, tomorrow. I'm so sorry. I'm talking nonsense. It's the next day. Yeah, you've got the whole of tomorrow. So you can divide your time as you see fit.
My lord, I would just like a similar amount of time to my learned friend, whatever.
So if you want me to sit early tomorrow, I will. Not with great enthusiasm, but I will. I will sit till 5. Okay.
Well,
So you will have 6 hours anyway, or thereabouts.
Yes,
Or 5 hours.
5 hours.
Yeah.
Well, I wonder, I actually have made quite good progress today in terms of getting through what I wanted to get through.
Right,
I've got to just...
Well, if you want to check, I have got a meeting in 15 minutes and another one at 5. I have other things to do, but if you feel confident that you can give your opponent adequate time to deal with the case tomorrow morning, starting, say, I don't know, 11 o'clock, I don't know when you're hoping to finish.
No, I wouldn't be so brave as to say that.
No, I wouldn't have believed you, I suppose.
I would have... well, I understand the usual time for sitting here is 10 o'clock.
Usual time is 10 o'clock.
It's 10 o'clock.
I mean, if you want, I'll start at 9:30.
Well, I wonder if I might accept that very kind of invitation, just because I'm very conscious that people have flown to be here for this hearing, and not to finish tomorrow would be a bit disastrous. As far as that's
No, of course.
And so if I could accept it, and if you finish early, we finish early, but if I could accept that kind of
Yeah,
invitation...
if you finish early, that would be very good news.
It would be, yeah.
Right. Right, we'll start at 9:30 tomorrow. Thank you.
Very much obliged.
I leave it to you to talk to each other to make sure you have an agreed timetable, leaving some adequate time for a reply.
Indeed.
So I'll see you tomorrow at 9:30. Thank you very much.
All right.